Okay, welcome everybody. My name is Joanna Cohn. I'm the director of the Institute for Global Tobacco Control here at the Johns Hopkins Bloomberg School of Public Health. And I want to welcome you all to our monthly Innovations in Tobacco Control seminar series. I'm particularly delighted today to be able to introduce our expert speaker, Dr. Benn McGrady. He's in Geneva, and I've got folks in the room here in Baltimore, US, and we've got a number of folks live online as well from a range of countries. So really excited that we can make this all happen. So let me introduce Dr. Benn McGrady. He's currently a technical officer at the World Health Organization in the Prevention of Non-Communicable Diseases Department. And there he provides technical expertise to WHO member states to build their legal capacity to help prevent non-communicable diseases. He's been at the World Health Organization for almost 4 years now, and he advises, throughout his career, he's been advising intergovernmental organizations, non-governmental organizations, and governments on international trade and investment issues. Before he was in Geneva, he was at Georgetown University at the O'Neill Institute for National and Global Health Law. And prior to that, he spent a few years at the Cancer Council Victoria, also involved in trade and investment law issues, advising them. He did his Bachelor of Laws and his PhD. His PhD was in International Trade Law at Monash University in Melbourne, Australia. And he did his Master's of Laws in Global Health Law at Georgetown University Law Center. And we all know him as a true expert, one of the world's experts in international trade and investment law. And we're so excited to have him here today to talk to us about the World Trade Organization's recent ruling on Australia's plain packaging law. So, Ben, welcome, and thank you so much for doing this.
Can you hear me? Hi, Joanna. Can you hear me?
We can. Great. Thank you.
Okay. Thanks so much for the invitation to speak in this lecture series. It's a great series, and I'm very pleased to be able to speak. And sorry that I couldn't be with you in Baltimore in person. Nonetheless, I think there's a lot of interest in this WTO dispute and its implications for not just tobacco control, but public health more generally. So I'm more than happy to be with you today. I'm assuming that you can see my PowerPoints on your screen. I'm going to just start with the conclusion of the presentation, which are what I think are the 5 key implications of this WTO dispute for public health, with a focus on tobacco control primarily. And it's important for me to stress here that these implications are not the 5 main implications for trade law. From a trade law perspective, this is an extremely complex dispute, and it throws up a lot of novel legal questions that I'm sure we'll see the WTO Panel Report cited frequently in other WTO disputes and also before domestic courts. But given that Johns Hopkins is a school of public health, I'm going to focus this lecture on what I see as the primary implications for public health research and for public health practice. The first of those, as you can see on your screen, is the most obvious, which is that other countries can take some comfort in moving forward with tobacco plain packaging as part of a comprehensive approach to tobacco control, now that we have the WTO Panel Report. I'll add some caveats to that throughout, but it's fair to say that the WTO Panel Report, in Australia's favour, completely in Australia's favour, is very good news for other countries wanting to implement tobacco plain packaging. The second main point, and this will really be the focus of much of what I have to say today, is that post-implementation evidence, that is evidence gathered after implementation of a tobacco control measure, and specifically tobacco plain packaging or another contentious measure, takes on far greater importance than it has previously in the context of legal disputes. I'll explain and unpack that in much more detail, but when we look at tobacco control law and tobacco control litigation in general, when courts are focused on questions of evidence, they're focused primarily on questions of evidence of risk rather than evidence of the impact of a specific intervention. Whereas this dispute goes in great detail into a discussion of the impact of the intervention on public health. The third point, which is less obvious, is layered policy objectives based upon logical pathways of policy impact can assist in defending regulations. This is true both before the WTO as well as before domestic and other international courts. In essence, governments should not pursue an objective simply of reducing the public health impact of tobacco use by reducing prevalence. Instead, they need to set out the logical pathways through which they will achieve that policy impact in order to make their measures as defensible as possible. And we'll see this in the discussion of the evidence in this dispute. Fourth, having an instrument like the WHO FCTC matters in legal adjudication. It played an important role in this WTO dispute. The FCTC has also played an important role in other international and domestic litigation on tobacco control. It matters, it has a big impact before courts. And then finally, something that I'll spend the second half of the lecture discussing is that future restrictions on use of trademarks may actually see courts weigh and balance the public interest associated with restricting use of a trademark as against the private interests of a trademark owner or trademark rights holder to, in essence, determine whether or not some restriction on use of a trademark is proportionate to a legitimate objective. This is a new approach in law, and it has, I think, potentially wide-ranging implications for not just tobacco control measures, but other measures that place limitations on marketing, advertising, and promotion, including on product packaging. We'll come to that in some more detail in the second half of the lecture. So they're the conclusions. Don't stop paying attention because each of them needs substantial explanation. And before I talk about the WTO Panel Report in more detail, I just want to give some of the basic context around tobacco plain packaging and ensure that we all have a common understanding of what that means and where we are. First of all, it's important to recognise that tobacco plain packaging is not a single intervention that's implemented on a standalone basis. And we can see this in the way in which the WHO FCTC, the Framework Convention on Tobacco Control, addresses plain packaging. First, with respect to packaging and labelling, we have a very general obligation to implement effective measures to ensure that the packaging and labelling is not misleading or false, as well as effective measures to ensure that health warnings describe the harmful effect of tobacco use. There are some minimum standards in those obligations, but it's a very general obligation to implement effective measures. We then, in Article 13, with respect to tobacco advertising, promotion and sponsorship, also have a very general obligation to undertake comprehensive ban or restrictions. And these obligations, each of them apply to parties to the Convention, 181 parties at present. We then have guidelines to certain provisions of the Framework Convention, which describe, in this instance, plain packaging. And you can see in the image on the left of your screen a mock-up of plain packaging from Australia, that this mock-up was created before plain packaging was implemented in Australia. And you see this in the definition. It's measures to restrict or prohibit use of logos, colours, brand images, or promotional information on packaging other than brand and product names displayed in a standard colour and font style. So the central characteristic of plain packaging is that the only branding permitted on the pack is the brand and possibly a variant name in a standardised font, style and size. All other features of the packaging are standardised. For example, the size and shape of the pack, the materials from which the pack can be made, the background colour, barcodes, manufacturer, producer names. They are all standardised to limit the ability of the pack to promote tobacco use and to appeal to consumers, among other objectives. The other thing to note about tobacco plain packaging is that it's called plain or standardised packaging, but in reality it also applies to the product. For example, the cigarette sticks or cigars themselves are standardised so that the appearance of branding or other promotional features on the product is also limited. It's important not to forget that because in the case of cigars, for example, there's quite substantial branding attached to the cigar stick. On cigarettes, there's also branding printed on the stick. And this can be used to circumvent or undermine plain packaging if it's not also covered by the law and regulations. This slide shows us basically where we stand today in terms of international implementation. From the top left of your screen, you can see Australia, New Zealand and Ireland. Those countries cover all tobacco products legally for sale in their jurisdictions with plain packaging. Category number 2, you can see France, Hungary, Norway and United Kingdom. These laws are all in place for these 7 countries. With category 2, some tobacco product categories are covered, but not all. We then have category 3, a number of countries that have passed laws on plain packaging but not issued their regulations. We're seeing some quite rapid changes in this. So since the graphic was created, Thailand has actually issued its regulations, and Uruguay has also passed a decree to implement plain packaging, although part of that has gone back to Parliament since. You can then see in category number 4 the different categories of products, not just the packaging itself, but the products that are covered under the laws currently in place. So while Australia was the first country to implement plain packaging, we've got 7 countries that have fully implemented since, a number that have passed laws and are in the process of moving towards issuing of regulations. And I think it's fair to say since the WTO Panel Report, there's been a fairly rapid escalation in interest in plain packaging globally. And just before we move to the WTO Panel Report, it's important to put that report in its broader political and legal context. What you can see here on the screen is a PowerPoint presentation. And as you can see from the logo on the bottom, it's a Philip Morris International PowerPoint. The PowerPoint was leaked and released in an investigative report by Reuters. And in essence, it shows Philip Morris International strategy to prevent plain packaging coming into effect. And there are a number of different tactics in this overarching strategy. The World Trade Organization dispute is just one. We've also seen substantial domestic litigation around tobacco plain packaging. In Australia's case, it faced a domestic constitutional law claim, the claim before the World Trade Organization that we're talking about today, and a claim separately under a bilateral investment treaty. In the United Kingdom, there was a domestic law claim, including a referral of certain issues to the European Court of Justice. In France, a domestic administrative claim. In Norway, a domestic law claim as well. So there have been a number of different claims. Some of them have also adjudicated certain aspects of WTO law, in the sense that they've had to interpret WTO law because it's incorporated into domestic law. The overarching point being that the WTO dispute is just one prong of, in this case, Philip Morris's strategy to prevent implementation of plain packaging. Now, it's a very important prong because most of the parties to the Framework Convention on Tobacco Control, for example, are also WTO members. And so there was always a risk here in the WTO dispute that a negative outcome would have far-reaching systemic implications, potentially not just for implementation of plain packaging, but also for tobacco control and public health more generally. So it's one prong of the strategy, but a very important one nonetheless. So let's turn to the WTO Panel Report. Now, you can see here the cover of the WTO Panel Report. And most importantly, if you look just above the line on the top right, you can see that this is page 1 of 884 pages. There are also 2 annexes that in essence mean the WTO Panel Report, which is like a judgment of a court on the legality of plain packaging in Australia, comes to over 1,000 pages. It's an extremely complex WTO panel report, and WTO law in general, I think it's fair to say, is also a very complex area of law. So what I'm about to give you is a very broad overview of the panel report and what I think are the key points of relevance for people working in tobacco control and the public health community. And first, we must start with some questions of process. Now, these may seem mundane, but in reality, they have important implications in terms of where we are and how WTO dispute settlement actually affects the behaviour of different governments. So we can see on this PowerPoint that the process underpinning the WTO dispute and the outcome that I'll be talking about in a moment started as far back as 2012. Yeah, we're now December 2018, and it's been a few months since the WTO panel issued its report adjudicating the dispute. There's been an appeal or 2 appeals lodged by Honduras and Dominican Republic. And it seems, or it appears at the moment, that we might have a report from the WTO appellate body in late 2019. Now, what does all that mean? Well, in WTO dispute settlement, it's possible for one WTO member or a number of WTO members to bring a complaint or series of complaints against another WTO member. In this instance, it was Ukraine, Honduras, Dominican Republic, Cuba, and Indonesia that brought complaints against Australia. It's only possible for WTO members to bring claims against one another. So that means it's only possible for governments to bring claims against one another. It's not possible for a tobacco company to directly bring a claim against the government, but it's fairly routine in WTO dispute settlement for companies to support complaints made by governments. The panel has issued its report. The panel here functions like a court of first instance or the trier of fact. And it's come down completely in Australia's favour for reasons that I'll explain in a moment. Only Honduras and Dominican Republic have elected to appeal. Ukraine actually dropped out of the dispute part of the way through. Now, in principle, a WTO panel or appellate body report, strictly speaking, only binds the parties to the dispute. So it would only bind the countries mentioned in this PowerPoint and Australia, in the sense that it only adjudicates their claims against Australia, in a sense, in a bilateral way. But in practice, WTO panel reports and the appellate body reports in particular are generally cited by subsequent panels, and it's very unusual to see a situation where a question of law, for example, is relitigated in WTO dispute settlement. It's only Australia's measure that has been brought to WTO dispute settlement. None of the other countries that I mentioned that have either passed plain packaging laws or implemented plain packaging laws, none of them has been challenged at the WTO. Excuse me. Now, I mentioned that the appellate body report is expected in 2019. In essence, Honduras and Dominican Republic are appealing certain questions of law to the appellate body. As has widely been reported, the WTO appellate body is in crisis at present, in the sense that WTO members are not making new appointments to the appellate body. It's effectively being blocked. At some point next year, the appellate body will not have a sufficient number of members to hear appeals, and it's unclear exactly which appeals we will have panel reports on next year before the system reaches a deadlock, assuming that new appointments are not made. But it's anticipated that we'll have a panel report before the end of 2019 on the plain packaging case. Not guaranteed, but anticipated. So, with all that context, let's start to talk in a bit more detail about the claims that were made and how they were resolved. I'm going to focus this presentation on what I think are the two central claims made by the complainants in this case. There were many, many claims made. I think these two central claims held the greatest potential threat to tobacco control and public health and are of the greatest systemic importance. So I'm going to focus on them. The first claim made was that Australia's plain packaging law is more trade restrictive than necessary to achieve a legitimate objective. In this instance, the legitimate objective of protecting human health. And as you can see on the slide, there were two central premises of this argument. The first is, as the complainants alleged, that Australia's law doesn't in fact contribute to the protection of human health because it doesn't reduce prevalence of tobacco use and therefore cannot be shown to reduce the public health implications or burden of tobacco use. Second, they argue that there are other less trade restrictive means to achieve the public health objectives underpinning Australia's tobacco plain packaging law. It's important to note from the outset that WTO law strikes what they call a balance between rights and obligations. It's a balance between the right to regulate, including in the interest of public health, and the trade obligations that WTO members have undertaken. And this balance finds expression sometimes in this concept of necessity and the necessity test, which requires a balance to weigh on the one hand the contribution that a regulation makes to protection of human health as against the extent to which it restricts trade. And it weighs, in the context of the TBT agreement, it weighs these factors in light of the risks that the government is seeking to address. In this instance, the public health risks associated with tobacco use and specifically the ability of the pact to promote tobacco use. Sometimes this test is referred to as like a proportionality test, where a panel is asked to evaluate whether or not, for example, plain packaging is a proportionate response to a risk. Strictly speaking, in WTO law, that's not exactly what it is, but I think it's a good way of explaining the process that the panel has to undertake. And there's a long line of case law in the WTO on the standard of proof. That is, what a government has to show, or a WTO member has to show, in order to succeed in the claim. Now, there's a difference, of course, between the burden of proof and the standard of proof. Here, the burden of proof rests on the complainants. So the countries challenging plain packaging had to actually show that it was more trade restrictive than necessary. Yeah, if they can, bring a prima facie case or show that at first glance there's evidence to support their argument, then that burden shifts to, in this case, Australia, to show that no, in fact, that's not the case. But when it comes to the standard of proof, there's a contribution made by a measure or a regulation like tobacco plain packaging, where we can say there's a genuine means-ends relationship. That is, a relationship between the ends chosen, plain packaging, and the objective that the government is seeking to achieve. So where we see this means-ends relationship, we can say that there is some contribution. It's a very judicial rather than scientific approach to determining whether or not some contribution exists. But there's also a lot of case law on the question of what types of evidence might be relevant to determining the degree or extent of a contribution made by a given regulation. And that's where I'm going to focus a lot of my attention in this presentation. So as you can see on the screen, governments can rely on either qualitative or quantitative evidence. In fact, there are no set rules on the types of evidence that a WTO member might rely upon in bringing their arguments, nor is there some threshold level of contribution that's required. There's also some accommodation in WTO case law concerning the difficulty of establishing the contribution of a measure to its objective in empirical terms. So, for example, there's language in a number of cases recognising the difficulty of disentangling variables or drawing causal inferences. There's also language in case law that recognises that for some complex public health or environmental problems, it might not be possible at the time of a dispute to identify the full impact of the regulation being challenged. And in this context, the panel's role, it's important to recognise, is not to settle scientific controversies or scientific disputes, but it's to evaluate in an objective fashion the sufficiency of the evidence relied upon by the government implementing the measure. This is very important, of course, because the panel is in its adjudication function, it's serving essentially a judicial function rather than a scientific function. And typically panels are not very well equipped to serve scientific functions. And in this context, the panels look at sort of traditional judicial type indicators of necessity or contribution. So they might look, for example, at the design, structure and operation of a regulation. And they might also look at evidence relating to the application of the measure. For example, post-implementation evidence of its actual application. And in this dispute, the panel looked at both of these types of evidence to assess the degree of impact on what the panel determined to be Australia's objective of improving public health by reducing the use of and exposure to tobacco products. We'll come back to this objective in some more detail in a moment. It's important to recognise that it's the panel that evaluates what the government's objective is. It's not for the government simply to state its objective and for that objective to go unquestioned. It's all the subject of dispute. We see here the Australian government's depiction of the operation of its tobacco and packaging measures. Yeah. And in essence, the objectives and pathways through which the government was seeking to achieve those objectives. You see on the left, you have the plain packaging measure, what are called mechanisms of plain packaging. The Australian government here calls them mediators, precursors, predictors, or leading indicators. Some, including at WHO, might refer to them as proximal impacts of the policy. So here, the Australian government's goals are decreasing appeal, increasing the effectiveness of health warnings, and decreasing the ability of the pact to mislead consumers. And then the objects of the actual legislation, the law, so discouraging people from taking up smoking, encouraging people to quit, discouraging people from relapsing, and reducing exposure to secondhand smoke. The public health outcomes, you see on the far right, lower prevalence, reduced exposure to secondhand smoke, reduced tobacco-related disease and death. Now, you, of course, could make this chart in different ways based upon the objectives of different governments. Some might also say that lower prevalence is not per se a public health outcome, but it's a proxy for a public health outcome in the form of reduced mortality and morbidity. But in any case, this shows basically the way in which the Australian government had set up its objectives, and the pathways for achievement of the objectives. This becomes extremely important in the dispute because tobacco companies focus their arguments around the evidence on the narrow question of whether or not plain packaging can be shown to have reduced the prevalence of tobacco use, and specifically smoking, in Australia. That's not the only line of argument that the complainants make, but it's the focus of their argument. And it's been the focus of argument in domestic litigation around plain packaging as well. Whereas countries are arguing that they can show proximal outcomes, such as decreased appeal, increased effectiveness of health warnings, tobacco companies are fairly consistently saying in domestic litigation, and the complainants said it here, that no, the true measure of public health impact is prevalence of tobacco use. And in making this argument, that the complainants sought to pick apart the body of evidence study by study. Now, thankfully, the panel looked at the body of evidence as a whole, considering it all together rather than taking individual studies and looking at their limitations. We see specifically with respect to pre-implementation evidence that this was considered most relevant to the proximal impacts or indicators or the leading indicators. So it's most relevant to the extent to which plain packaging contributes to reducing the appeal of tobacco products. It's most relevant to noticeability of health warnings, their perceived credibility and seriousness, as well as also to the question of whether or not plain packaging would reduce the extent to which tobacco packaging misleads consumers. Now, this pre-implementation evidence is comprised of peer-reviewed evidence from a number of different countries that tested plain packaging in slightly different forms, but nonetheless produced fairly consistent conclusions. And in WHO's view, those consistent conclusions testing plain packaging using different approaches in different places suggested that many of those conclusions were in fact generalizable, that we can say plain packaging reduces the appeal or attractiveness of tobacco products, that it does increase the effectiveness of health warnings, for example, their noticeability. It can reduce the ability of the pact to mislead consumers. And of course, it reduces the ability of the pact to promote tobacco use. But the panel also looked in substantial detail at post-implementation evidence. And this was both qualitative and quantitative evidence, focused primarily on the question of the impact of plain packaging on prevalence, but partly also on the impacts of plain packaging in Australia on those leading or proximal indicators of effect. Now, on appeal and on the question of the effectiveness of health warnings, the panel found in Australia's favour, that plain packaging had reduced appeal, had increased the effectiveness of health warnings, but found the evidence on misleading packaging was not as conclusive. Similarly, the evidence on actual quit attempts, so behaviour change by consumers caused by these proximal or leading impacts of reduced appeal, there was mixed evidence. For example, we could see that calls to the quit line, a cessation service, a government-run cessation service, had increased dramatically, and pack avoidant behaviour had increased. For example, consumers were placing tobacco packaging on tables at cafes less and displaying tobacco packs less in social settings. But there was still some mixed evidence on these indicators. And in many respects, an econometric analysis of smoking prevalence in Australia became a key part of the evidence post-implementation. You can see here on the left a chart, a prevalence trend that the Australian government produced. And in essence, we see this dramatic drop in the prevalence of prevalence of smoking, adult smoking in Australia after implementation of tobacco plain packaging. And we can see a green line, a second green trend line, which shows the new trend, or what the Australian government argues is the post-2012 trend. Now, of course, plain packaging is implemented at the same time in Australia as revision of graphic health warnings. So there are new images being rotated onto the pack, and the size of the warnings increases at the same time. There are also changes in tobacco tax policy to increase tobacco taxes. And the chart doesn't disentangle these variables, but the econometric analysis seeks to do that. It seeks to control for these and other variables. And it concludes that the accelerated drop in prevalence in Australia can be attributed to plain packaging and new larger graphic health warnings. At least a proportion of it can. The panel looks at all of this evidence as a whole, and it recognises from the outset the inherent difficulty of isolating the impact of plain packaging on, for example, the prevalence of tobacco use. But the panel concludes that the appeal of tobacco products is reduced, and that health warnings have become more noticeable on product packaging. It concludes, as a finding of fact, that the drop in prevalence has accelerated, and that plain packaging and the new and large graphic health warnings had a statistically significant impact on the prevalence of tobacco use and cigarette wholesale sales. So remember when I said at the start, the panel says that they don't have a function of settling scientific controversies. Rather, their role is just to determine the sufficiency of scientific evidence. Here they actually go on and conclude that the evidence supports the conclusion that the plain packaging with these larger graphic health warnings and other measures implemented by Australia has reduced the prevalence of tobacco use. The panel doesn't quantify this reduction, but it describes it as a meaningful contribution. Yeah. So they were looking at establishing the degree to which plain packaging has contributed to Australia's objectives, and it says it's a meaningful degree, it's a meaningful contribution, but doesn't qualify. These findings of fact, of course, are very important in the sense that the appeal that's been lodged by Honduras and Dominican Republic, the appeal is limited to questions of law, not to questions of fact. Now, they're actually trying to argue that the panel has not engaged in its analysis in an objective way. The roughly 1,000 pages of detailed analysis Honduras and Dominican Republic are saying is not objective. But there are very important conclusions of fact here about the implementation of Australia's measure that will no doubt be influential in the appeal. So after drawing these conclusions on the contribution that plain packaging makes to achievement of the objective, the panel goes on to find in Australia's favour that the complainants, the countries challenging the measure, have not established that it's more trade restrictive than necessary to achieve Australia's objectives. Now, in the process of finding this, they weighed this contribution that Australia's measure has made against the so-called trade restrictiveness of the measure, the extent to which it restricts trade. And here what they really said was, well, if there's a drop in prevalence, it restricts trade by reducing trade volumes. But of course, in the process, they, in essence, trap the complainants, as is the case in so much domestic tobacco control litigation. The complainants here are arguing, on the one hand, it's not an effective measure, it doesn't reduce prevalence, but on the other hand, they're arguing it's somehow trade restrictive and has an impact on their interests and rights. And it's very difficult to make those two positions coherent, because if there's actually no drop in the prevalence of tobacco use or no impact on sales, for example, then it's hard to see how their rights are prejudiced. In any case, the panel here also looks at arguments from the complainants that there are a range of other tobacco control measures that could be used to achieve Australia's objective. The panel rejects these arguments, saying in most instances these measures are already in place. For example, Australia has large graphic health warnings in place. It has a comprehensive ban on tobacco advertising, promotion and sponsorship. It also has these other measures in place, and some of the proposals made by the complainants, like increasing minimum purchase age or additional tax increases, or actually looking at individual packs to see whether they're misleading or appealing, the panel rejects for various reasons. After weighing all the factors, it finds in Australia's favour. It's not more trade restrictive than necessary to protect human health. Keep in mind what I said at the start, that plain packaging has been challenged before domestic courts. Domestic courts use variations of this type of test, whether it's a proportionality test, whether it's a reasonableness test or a rationality test or means ends analysis. Domestic constitutional courts use this type of legal test or legal analysis in adjudicating claims about competing rights, whether it be protection of property rights or protection of the right of free expression as against the public interest in protecting health. So in this sense, this conclusion from the panel, assuming it's upheld by the appellate body, I think is going to be something that will be routinely cited before domestic courts if there are further challenges on plain packaging. The second central claim of this dispute concerns protection of trademark rights. It's quite common for tobacco companies to argue that large graphic health warnings or other packaging and labelling measures interfere with their trademark rights. And here the complainants relied on an obscure provision of the Agreement on Trade-Related Aspects of Intellectual Property Rights, called TRIPS, a WTO covered agreement which requires WTO members to ensure minimum standards of protection for intellectual property rights, including trademark rights. And the complainants say that, well, they do, two of them at least still say that Australia's plain packaging law unjustifiably encumbers use of trademarks with special requirements. And here on the screen, you can see an image from Australia of a product, JPS. On the left-hand side of the picture, you can see the colour blue, you can see stylized logos, you can see dots on the pack that probably are embossing of the pack, various packaging features, all or some of which would be protected trademarks. And in essence, the tobacco plain packaging law is restricting or prohibiting the use of these trademarks on the pack, because the only form of trademarks that can be used are word marks, in this case JPS Blue, which you can see on the image on the right. Now, the arguments here again are premised on the idea that plain packaging doesn't contribute to protection of human health. The panel's already rejected that argument. In addition, the complainants argue that this is an extreme restriction. We've never before seen restrictions like this on product packaging, and it substantially undermines the protection of trademarks and the trademark regime as a whole, they say. They don't argue that trademark owners have an actual positive right to use their trademark. They don't under WTO law. It's a right to prevent others. For example, if I own a trademark, I can prevent you from using it in certain circumstances. But I'm not allowed some unrestricted or unlimited right to actually use it however I want in the course of trade. Nonetheless, they put this sort of very legalistic or formalistic approach to the side, and they say trademark owners still have what they call a legitimate interest in using their trademarks. Even if they don't have a right under the law, they have a legitimate interest. And in this context, they say that the restrictions are unjustifiable because that interest has been substantially eroded. Now, here the panel agrees with this argument that there is some legitimate interest beyond the strict legal rights that are created by the law. And the panel says when we restrict use of trademark rights, or when WTO members do, there has to be this case-by-case analysis of the nature of the restriction or encumbrance, the reasons for it, including the societal interest or the public interest for it, and whether those reasons provide sufficient support for the encumbrance or restriction. Here, on the facts, the panel looks at the restrictions and it says, well, trademarks can still be registered. A trademark owner can still prevent third parties from using their trademark. Yeah. And trademark owners can still use word marks to distinguish their products from one another. But the restrictions or prohibitions on stylized or figurative trademarks like colours or logos are considered quite far-reaching. Nonetheless, the panel draws on a long history of WTO case law to stress that public health is an objective of the greatest importance, including under WTO law. And it relies on its findings of fact that plain packaging is contributing to protection of public health. And it finds that plain packaging does, or there is sufficient support here to justify the restriction. And here, as in the analysis under the TBT agreement, the panel relies on the WHO FCTC. It also here relies on Doha Declaration on TRIPS and Public Health, which stresses that intellectual property rights are designed to ensure broader public or social objectives, including protection of health. So, in conclusion, this is my last slide, that I come back to these main implications for public health. So there's this extremely detailed analysis from a WTO panel on Australia's measure, and no other countries have been challenged before the WTO to date. So countries can take some comfort in moving forward with plain packaging as part of a comprehensive approach. Recall that Australia's measure is implemented in concert with other measures, including large graphic health warnings and a comprehensive ban on advertising. And it's in this context that it's justifiable to say that plain packaging reduces the attractiveness or promotional characteristics of the packaging. So we at WHO only recommend plain packaging as part of a comprehensive approach. My point about post-implementation evidence, in a context where tobacco companies or governments, as in this case, are going to really challenge the effect of an intervention after it's been implemented, then post-implementation evidence takes on much greater importance than we've seen in prior WTO case law and in prior disputes concerning tobacco control measures in other jurisdictions. Here, the layered policy objectives and that sort of logical pathway to impact that the Australian government established was very important in defending the measure. If the Australian government had simply had to argue that we could see a reduced prevalence, I think it would have been a more difficult argument to make. Certainly, the Australian government was on stronger ground by relying on a variety of different data points rather than just one or two econometric analyses of reduction in prevalence. The FCTC matters. The panel relied upon it in multiple respects throughout the panel report. And then finally, future restrictions on trademarks. We see already in the context of obesity prevention or regulation of breast milk substitutes, the governments restrict the presence of trademarks on product packaging. For example, they might be cartoon characters on foods high in fat, salt, or sugar. Or they might be logos or trademarks used to promote breast milk substitutes. In essence, what the WTO panel has done here, assuming the appellate body upholds this approach, is create a system where WTO panels will have to weigh the public interest against the private interest of trademark owners or rights holders to determine which prevails in the event of a dispute. So in some respects, the WTO panel, both in the TBT analysis and the analysis under TRIPS on trademarks, is establishing itself as a court of last resort almost on some of these complex regulatory issues. No doubt I've spoken for far too long. As I said, that's an oversimplification of the 1,000-odd pages of the WTO panel report. But Joanna, I'll throw back to you for questions and comments.
Ben, that was fantastic. Thank you so much. And it's incredible how you've been able to so clearly summarize those 1,000 pages in a very practical and helpful way. So thank you so much for that. We did have a question that came in through the group chat a bit earlier about recommendations for low and middle income countries who are interested in plain packaging. And I think your recommendations do address that, but is there anything in addition you would like to add, particularly for low and middle income countries?
Yeah, thanks, Jonah. It's a good question, partly because if we look at that list of countries that have implemented plain packaging to date, they are developed countries. We're seeing now a new push from low and middle income countries. I think the first recommendation, the most important, is do it as part of a comprehensive approach. So there should be a comprehensive advertising, promotion, and sponsorship ban in place. There should be large graphic health warnings in place at a minimum. The second implication, we've seen some countries do pre-market testing or focus group studies prior to implementation of plain packaging, for example, to determine the least appealing form of tobacco products. Australia did it, Canada's done it, Singapore has done it. They've produced fairly consistent conclusions, but it's an expensive and time-consuming undertaking. So for governments that either don't have the resources, human resources or financial resources to do that kind of testing, we say to them if they're not going to do it, then base their measures as closely as possible on Australia's approach, unless there's good reason to change or to alter something.
Great, that's really helpful. Thank you. So, one of your recommendations was about some of that post-implementation surveillance and assessment. Are you aware? It's so hard. Countries, in the policy environment, spend all their energy, not just the governments, but the public health sector, the lawyers, getting the policy on the books and passed, and then it's really hard to make sure that post enactment phase happens. Are you aware of the countries that, besides Australia, that have implemented plain packaging or are very close to, do they all have their systematic approaches planned or even started to assess what's happened given after the policy was implemented?
Good question. There are different approaches in different countries. I think Australia is the most comprehensive approach, and as the first country to implement, as far back as 2012, there's the most data there from Australia. Australia was also very fortunate in the sense that there's good data sets on tobacco use prevalence and particularly smoking prevalence, both government owned or controlled data sets, and then also data sets from the private sector as well. And then there were also researchers laying baselines prior to implementation on some of the proximal or leading indicators. For example, a year before implementation, at the time of implementation, and then doing post-implementation studies. So by far the data coming out of Australia is the most comprehensive. Out of countries like the UK and France, there's some data that points in the direction of plain packaging having a positive impact, but it's very difficult to draw causal inferences and say that the positive impacts happening in those countries are solely attributable to plain packaging, because there are other things happening at the same time.
Yeah. I'm going to ask you one more question, and I apologize for taking the chair's prerogative, but I want to ask you one more question, and it has to do with one of your recommendations or your summary points about the importance of the FCTC. So you're sitting in the NCD department at WHO and interested in other non-communicable diseases and risk factors, not just tobacco use. So what would you recommend to folks who are interested in alcohol or food or other kinds of risk factors for NCDs who don't have an equivalent of the FCTC behind them? Like how essential was that? And is it important maybe before putting forward these very innovative policies, groups should really work to implement a framework convention for other risk factors first?
Yeah, good question. So that I don't exceed my mandate here as a WHO employee, I'll stick to description rather than advocating one approach or another. What I can observe, having been involved in FCTC processes and in plain packaging, is that first of all, the development of guidelines to the FCTC on plain packaging gave the first movers, the governments, a great deal of comfort as they went through the policy process. Second of all, when we look at legal disputes, it's clear that courts sit up and take notice of international legal instruments. That's not to say that guidelines, international guidelines, standards or recommendations or non-binding or non-legal instruments are irrelevant in domestic courts. Clearly they can still be relevant, but courts place, I think, a great deal of emphasis on legal instruments. And in the disputes around plain packaging so far, there's been, I think, very substantial and important references to the FCTC in those disputes. The disputes may have turned out the same way in the absence of the FCTC, and certainly courts have based their judgments on the evidence and the law. But we do see the FCTC playing an important role in this context. So for other risk factors, sticking strictly to description, and here prediction based upon that description, it would be reasonable to think that if there were international legal instruments in other areas, then domestic courts might place more emphasis on those in the event of disputes like this than they would on, for example, guideline standards or recommendations coming out of WHO or elsewhere. But that's prediction. Take it for what it's worth. It's not intended to say that regulations on obesity prevention or alcohol regulation need a framework convention in order to be consistent with WTO law or consistent with any other body of law. My statement's not intended to suggest that.
Okay. Well, on behalf of all the folks that hopefully you can see in the room here in Baltimore and our folks online as well from multiple countries, thank you so much for your, again, very clear and helpful summary of the WTO ruling. Thank you so much, Ben.
My pleasure. Thanks for having me.
Great.